Perfect.
Good morning, Colorado and others, if others are joining us. Our participants are now engaging, so we're going to give them a second to log in to our Zoom meeting. My name is Jeff Robbins. I'm chairman of the Colorado Oil and Gas Conservation Commission, and this is day 4 of our rulemaking. We're allowing folks to continue to sort of Zoom in here. Appreciate everybody's attendance and participation with us. Let's give it a second or two and then we'll get started. Okay, looks like we've leveled out at about 118 participants. Hearings Officer Larson, if we could start with the roll call.
Certainly. Commissioner Gibbs.
Here.
Commissioner Gonzalez.
Here.
Commissioner McGowan.
Here.
Commissioner Mesner.
Here.
Commissioner Nanjapa.
Here.
Commissioner Putnam. Commissioner Robbins.
Here, and I believe Commissioner Putnam is also here.
Yes, I'm on. I'm in a hospital waiting room, but I'll be out shortly, but I'm listening.
Great. Thank you, Commissioner Putnam.
Thank you. Mr. Chair, you have 7 out of 7 commissioners present.
Okay, that's great. We're going to move into party presentations here in a bit. We'll start with Small Operator Society. Before we do that, though, I wondered if the commissioners would indulge me in having a little bit of a process discussion so that you can be thinking about where we go this afternoon when we start into deliberations. One of the sort of, we've received a lot of information over the last several days, which is awesome, to help us direct our deliberations. And I wanted to sort of think about next steps. I put some thought into this last night as I was sort of thinking through what we've received and where we're going. And I wanted folks to sort of think, so I've been sort of thinking about the issues that exist before us and sort of the competing ideas. And there are, a half a dozen so of sort of high level issues that I think we need to start thinking through. And what I was wondering is, could we start this afternoon in deliberations with the idea of issue identification? So let's create a list of things that we need to be thinking about. And then sort of walking through that amongst ourselves as commissioners at sort of a high level and seeing if we can get to landing spots at sort of the 30,000 foot level on some of those big ticket issues, and then giving direction to staff to come back to us with more detailed language around issue identification and moving through how we get through these sorts of things. And then giving staff a chance to do that over the course of a period of time. Say staff gets back to us with proposed solutions on some of these big ticket issues, and then we get that early next week, and then we set aside a time next week after we've had a chance to sort of think about staff's response to our 30,000 foot landing areas, and then we can work through the staff response and get to hopefully some landing spots on some of these big issues. It's just a concept, it's just an idea. We have pledged to be nimble and fluid as we move through these sorts of things. In my mind, what that's doing is allowing us to engage amongst ourselves on some of these issues, but it's not requiring us to find finite, specific, tailored answers on big issues today. And it also is allowing us to use our staff in a productive manner to help us get to right spots. So don't mean to throw things out there. We can just, we can leave this discussion at that point right now, but I wanted to get two commissioners some of the ideas that are floating around in my head about how to productively move through some of the issues in which we are seeing sort of some folks are over here and some folks are over there. So, and we're all new to working together, but it just seemed to me that I wanted to sort of throw that out there, get you guys starting to think about it. We can move now into, witness testimony. We can have further discussion about these ideas. You can tell me that I'm all wet and that we should do something different. There's no right, wrong, et cetera, but just did want to kind of lead off with getting us to start thinking about how we process through issues that are on both sides of the equation. Commissioner Metz.
Thank you, Mr. Chair. I mean, I do think that's an important concept. I do think there's some issues that we're going to want to talk about. I think we want to identify those issues. I think we want to bring in, bring it in at a high level, and then certainly give staff enough time in order to develop the wordsmithing in order to, perhaps get into language the concepts that we're bringing forward. I certainly think it's always a challenge to try to do wordsmithing on the fly. I don't think it's a great idea to have 7 commissioners trying to wordsmith the same document all at once in a live format. I do think that timeline that you've kind of laid out makes some sense to me. Develop the ideas, develop the concepts, and then give it a couple of days to be able to craft the language, and then get to a point where we may have to wordsmith as a group if we're not, in order to get to a consensus. So I think that makes sense.
And thank you, Commissioner Messner. And I see Director Murphy is here, and I apologize for throwing this on your lap without sort of thinking through it with you, but would be interested to hear from other commissioners as well as yourself, Director Murphy.
Chair, anything that gives staff a little bit of time to work through direction from you, and also some of the red lines and comments that we've gotten through these last couple of days, I think would help us get to a better spot in language. And I think the anxiety of editing in real time in front of 150 people, it just makes my heart palpitate. Because everybody notices your commas and misspellings, and then you slow down and get even more awkward. So I would love to do that, not in front of 200 of my closest friends.
Commissioner Najapa.
Mr. Chair, I agree with the comments that have been raised, especially by you and Commissioner Messner with respect to identifying the issues, and definitely would agree that it would be better to have the staff come up with some draft language based on what we talk about as those high level issues. And then, we can sort of react to that later as opposed to wordsmithing by commission.
Thank you.
I've got a clarifying question. Does this time add to, does this time allow for staff to engage with stakeholders to maybe find some common ground on some of these high level issues that they know at this point when we're deliberating that we'll be considering, and maybe some of the concerns we have with some of them? I want to make sure that we're not rushing and we're getting to the right spot. And so as much engagement as we can get, I think it's beneficial. And I don't want to put any pressure on staff or on us as commissioners to force this in too quick of a way. So I agree with high level issues, and then we'll go from there.
Yeah, and I think that, I appreciate you making that point, Commissioner Gonzalez, that actually was part and parcel of the approach. Is this would give staff. So if we have discussion and sort of send smoke signals about this is the places we see these things need to go, without defining exactly how that happens, I think it does give staff the ability to then discuss with the parties and stakeholders, hey, this is what we kind of heard. We want to talk with you about how we land that in terms of actual language. And Director Murphy, does that, and I'm speaking for you, but is that something that you think you could do with our highly, educated staff in terms of having some of those discussions?
Chair, thank you for the question. I do think that, I think there's probably a spectrum of word changes. Some may be fairly straightforward and may have kind of a direct, you need to include X in list of Y. And that's pretty easy for us to execute, right? Some of the more nuanced conversations may take a little bit more time. And so I know that we are all committed. I think I've had incredible outreach from the parties even over the course of the last few days. And I think that they're available and willing to have conversations. So yes, I think we could turn it around. If there are some bigger, more difficult issues for staff to work through, we might need a little bit more time, but we can always do kind of a rolling, here are the first suite of changes and we need a little bit more time on issue B. So, but yes, I think that's feasible. And also understanding from commissioners the stakeholder input or the party input that was particularly impactful on a topic will help guide where I need to really engage my time and with parties. So.
Great. Commissioner McGowan, thoughts, pro, con, etc.
Thank you, Mr. Chair. I guess I would say that I support what everyone else has said. I'm a little worried about some of these issues and wondering, I guess we're going to find out through conversation, wondering if we're going to have enough direction for staff to be able to take it and run with it. But I think we'll discover that through the conversations we have with each other. So I'm supportive of taking these concepts and having a robust conversation about them and giving hopefully some staff direction so they can work on language. So I think it's a good idea.
Okay, well, good. I'm glad we sort of have consensus around that. The way that the agenda was set up, it sort of required figuring out 300 series before we move to 500. But I think we can be nimble and I think we can sort of do this, get to high level, hopefully consensus on some of these things, give direction to staff, start into 500, get something back from staff, and then at some point next week, sort of reserve a half a day to sort of get further close on resolving 300 so we can kind of, again, be nimble. Commissioner Njapa, did you have further?
Yeah, and I hope I'm not, thank you, Mr. Chair. I hope I'm not speaking out of turn here, but I know we had some earlier conversations about kind of the larger overarching process with respect to a little bit of what you just were talking about, that we aren't, as I understand it, and would want the other commissioners' thoughts, we're not finalizing any particular series through this process because of the interactions with all of the different pieces, and that we would be discussing and continuing to potentially ask for additional information as we go. Is that correct? That's my perspective. I mean, I think that we're trying to sort of walk that tightrope of getting to some conclusions on some of the issues around 300, but knowing that nothing is final, because when we start to talk, I mean, let me just take a specific. When we start to talk setbacks in 600, that might influence ALA in 300. And so I think that we just need to realize that this all, at the end of the day, we're going to need to put all the pieces of the puzzle together in one time. But I think we can, start to find, in my puzzle thing, find the outerlying, things. When you put a puzzle together, you try to figure out the outerlying ones. So exactly. So we can start to do that, knowing that the inner parts still aren't done. Okay, I'm seeing nodding of heads, so I think we've got a good process. And I felt like it was important to sort of talk about this at the beginning of today so that our stakeholders can all sort of get a sense of how we're going to do this. I also wanted to give commissioners a sense of, if this is where we're going, be thinking about your list of issues so that when we jump into this, we will, all have our list and we can kind of compare notes and see how close we are. So with that, I think that we will move back to our regularly scheduled agenda. And Ms. Larson, I believe we have Small Operators Society up first for witness panel. And my
my agenda says they have 20 minutes. I don't know if that's correct or not.
That is correct.
So if you want to bring on board Small Operator Society panelists, we will look forward to hearing from them.
Super. Mr. Ratliff is in the meeting, as is Ms. Brodsky. So I think we're ready to go.
All right, I see that both of you have unmuted yourselves, so I'll let you figure out who's going to go first.
Okay. Thank you very much. Good morning, commissioners. My name is Dale Ratliff from Williams, Weiss, Pebble and Ferguson. I represent CPX Peons Holdings LLC, a member of the Small Operator Society. As Ms. Larson noted, also with me on behalf of CPX and the Small Operator Society is Gwen Brodsky from Tetra Tech Inc. I will speak first to two of CPX and SOS's broader policy and legal issues, and then Gwen Brodsky will speak to the expiration and permitting framework, the cumulative impact evaluation, and comprehensive area plans. I believe we have about 20 minutes of testimony we've dedicated to the 300 and are looking to reserve about 3 minutes for closing, though I know Ms. Larson will keep time and inform me of our time when we're done. As an initial point, SOS continues to have significant concerns with the general discretion afforded the director and the commission throughout the 300 series rules. As noted in our filings, the proposal to vest complete authority with the director or the commission to determine in their sole discretion what is necessary and reasonable to protect public health and the environment will convert a prospective regulatory framework into one where the director or commission will make case-by-case determinations without any clear parameters to guide those decisions. This raises a number of serious practical concerns. Operators need certainty of obligations and restrictions to reasonably plan for development. The whole purpose of a regulation is to be transparent and definitive as to what will be required of the regulated community, and advance notice of the obligations can better help companies both plan for and comply with those regulations. The Commission is also inviting every permit application process to become a case-specific adjudication over whether additional measures are needed beyond those required under the rules. SOS disagrees with the statements made by staff that the rules provide clear criteria. The direction to minimize adverse impacts or to impose conditions necessary to protect public health and the environment are inherently discretionary and will invite challenge and interpretation in individual cases. This will not necessarily result in better environmental outcomes. It will simply drain agency, operator, and public resources and will only result in continued unfruitful debate. The Commission has brought all the relevant stakeholders to the table for a comprehensive rulemaking. This rulemaking should define with specificity the requirements necessary to protect public health, safety, and welfare. If the Commission identifies a gap at a later date, it can fill that gap through rulemaking. This will ultimately prove more efficient and more equitable by creating prospective, consistent standards. And I think the level of engagement and the thoughtful discussion that has occurred during this hearing perfectly exemplifies why rulemaking is the appropriate forum for promulgating substantive obligations. This position is also consistent with some of the statements we heard in filings and in some of the testimony we heard yesterday. But the solution to dealing with the ambiguity under the rules is not to define the term minimize adverse impact. The solution is to promulgate the regulations that effectuate that goal. It's the regulations themselves that define what is necessary to protect the environment and to minimize adverse impacts to public health, safety, and welfare. That's the way the administrative process is intended to function. As a second point, SOS continues to believe that the alternative location analysis requirements should be more limited in scope. SOS continues to assert, as stated in our filings, that the proposed criteria for triggering an alternative location analysis are overly broad and exceed the plain language and explicit direction from the General Assembly. SB 181 is a broad, comprehensive statute. The Commission should interpret its authority under that statute rationally and within the clear boundaries set by the General Assembly. For example, Ms. Mendoza-Cook, who testified on behalf of the industry group, articulated the sweeping nature of the proposed ALA trigger for high priority habitat. This trigger has the potential of capturing a significant number of smaller facilities in rural areas that were not likely intended to be captured by the General Assembly when they promulgated the ALA provisions in SB 181. And these facilities will be subject to a comprehensive suite of regulations and will require consultation with CPW. There's not a need for another regulatory overlay in those circumstances. As to what constitutes an alternative location for purposes of the analysis, SOS appreciates staff's acknowledgement that alternative locations must be those from which the targeted minerals can be accessed. This is an improvement over the prior draft and helps put important and reasonable sideboards on the scope of the analysis. But SOS still believes that the commission should not require operators to undertake the process of identifying locations that they don't have rights of access for in order to develop. It's unclear what this information is intended to provide, other than potentially allowing the commission to force operators to enter into negotiations with surface owners unwilling to provide access. As Mr. Antonio testified the other day, a lot of thought and process goes into selecting proposed locations. And in rural areas and mountainous locations on the western slope, those locations can be somewhat limited. Asking operators to potentially negotiate with uninterested surface owners has the potential to strain relationships between operators, the public, and potentially even the commission and the public. Thank you, and I will now turn it over to Gwen Brodsky.
All right, thank you. Are you hearing me okay? I'm going to share my screen. And are you able to view what's on screen?
Yes, we can hear you and we can see your screen. Thank you.
Okay, excellent, thank you. As Dale said, I'm Gwen Brodsky. Thanks for the opportunity to speak today. I'm from Tetra Tech. I wear two hats. I'm an environmental consultant. I implement the rule language, so translating it into accurate permit applications is key for what I do. But I also spent 16 years as an employee at the U.S. Environmental Protection Agency and the Montana Department of Environmental Quality. So I appreciate the process of drafting language and communicating intent from the agency's perspective. I represent CPX Peons Holdings and Small Operator Society today, of which CPX is a member. And the Small Operator Society, just to give you a flavor, these are largely small operations, typically in rural areas. They may have just a few wells, many of which are on the western slope. And what we'll focus on in our comments are cumulative impacts, expiration dates, and comprehensive area plans. Now, cumulative impacts formerly were very general. The first versions of the rule language talked about analyzing broad categories: air, water, ecosystems, wildlife. And we did take a close look at the August 17th revisions. This was helpful because that earlier language led commenters to propose to the commission that they adopt a NEPA framework as a default in the absence of more specificity. But with the August 17th revisions, we do see a more defined framework that provides a lot of specificity. And we think that this is helpful. And it makes more sense than imposing the large federal NEPA cumulative impact analysis scheme on operators. But with that in mind, we still, and we list here, think there are some categories that are still overly broad. And we would ask the commission to consider, how would an operator implement these provisions? How would you populate a Form 2B? And we see that some of them do have specificity in the data, but at the bottom of this screen are examples that do not. They're still broad. So for example, the impacts to public health from emissions, which is a very heavy lift of epidemiology, but that information is already baked into the air quality standards when they're promulgated. And then those standards flow down and they become permit limits. So when the operator is asked by the commission to provide the emission data, that can correlate back already to health impacts, and the commission will have information that it needs to use. Another example are these migratory corridors and flyways and seasonal usage. We understand the intent for this provision. It's explained in the statement of basis, The challenge is that that information doesn't exist on a global scale. There might be some anecdotal information, there might be a study in a specific area, but there just isn't a blanket resource to find that information. We did listen as Mr. Holmstrom from Backcountry Hunters and Anglers explain that this data is a priority for that group and they're working with some agencies and it might be available in the future. And then the last example here is ecosystems, where the commission should ideally translate this provision. How would it be implemented? How would you populate a Form 2B so that the provision is not overly broad? And I'd like to turn to expiration dates, which is our second point, and point out that these timetables are very important. These will become real numbers very soon, and they have a lot of implications for processing permit applications and for expiring permits. The first thing to point out is how all of these permits, the Form 2s, the Form 2As, now tie to demonstration that an operator has commenced drilling a well. What's problematic, the commission staff pointed out this was done to make sure that operators are showing timely development, and we understand that. The challenge is not all of these locations will actually support a well. Some of them, as the Rule 100 definition points out, will only be used for treatment and processing equipment. They won't have a well, so they'll never be able to demonstrate drilling a well. So to correct that, we suggest the language be commence construction of the location, not drill a well. And then currently, as we look at the expiration dates, these oil and gas development plans expire in 3 years. And when they expire, they take with them the Form 2s and 2As unless drilling has commenced. That's problematic because those expiration dates may expire prematurely. That permit may only have a 1 or 2 year life. If it hasn't been issued at the same time as the oil and gas development plan, it doesn't get a full 3 year life. And the statement of basis did explain the intent here. The commission would like to see that the oil and gas development plans remain the mechanism to determine where operations will occur. But those decisions are already made. The Form 2 and 2A permits have already been issued. So we're simply requesting that those permits be allowed to be used for their entire natural 3 year life without expiring. And I should point out that 3 years to use a permit is not foot dragging, particularly on the western slope. This is an area where snow melts late in the season, often around May. It starts falling again in October. By November, your field season is done. And the challenge is that in between, you're further constricted because you have seasonal wildlife restrictions, access agreements, there are commodity price swings. You're trying to use that permit by completing that final detailed design, mobilizing crews and equipment. Having just 1 or 2 years left on that permit is just not practical. And this is exacerbated because the rule language no longer allows for an extension on the permits. And then we show in this framework that the suggestion an oil and gas development plan is supposed to frame and span the permits under it. And a way to do this is to make that a 5-year plan in order to span the 3-year permits under it. And the oil and gas development plan should remain valid for the life of those permits so that they can be utilized. And then this comprehensive area plan is supposed to be even further overarching. It's a long-range plan. And right now, the challenge is that a 3-year oil and gas development plan and a 5-year cap are just barely distinguishable. That 2-year increment is just not enough of a differentiator. And we know that 10 years is reasonable because that was the number in the original straw dog rule that was issued by the commission last winter. And so my last slide, we'd like to dial in a little closer on the comprehensive area plans with a couple of points. It's been said this week, comprehensive area plans are not new. These were formerly CDPs, comprehensive drilling plans. This is the second time since 2008 that rulemaking has focused on what now are CAPs and tried to encourage their use. This provides landscape level planning and systematic planning, but so far in all of these years, only one operator has a comprehensive plan. So right now with this rulemaking, it's really an excellent opportunity to make sure that CAPs aren't once again underutilized. A commissioner asked this week, is this just a matter of adding more incentives? And it's really not. It's more a matter of how are these incentives drafted? And the first one is duration. The request here is that the very real benefits of long-range planning not be eroded by converting CAPs into these short-range 5-year plans. We appreciate that the Commission did add language on August 17th to say that an operator can request an additional duration at the time that they submit the CAP application, but that's really putting the cart before the horse. Operators really need some certainty, which is the purpose of the rules, to understand what the outcome will be at the outset. Otherwise, on paper, the CAPs only demonstrate an additional 2-year increment of approval. And the labor and the time and the cost that go into that CAP process are very real for small operators. So the investment in that process needs to represent value beyond simply doing the oil and gas development plan. So our request would be to look one last time at that time frame process logic and how these approvals fit together between the permits, the oil and gas development plans, and the CAPs, which could be actually very helpful in seeing that these CAPs are more widely used and reach their potential as intended. And then the last point is this issue of this notion of durability. And with that, we mean that the issues already analyzed and approved in a CAP should not be revisited and reopened with every subsequent oil and gas development plan and Form 2 and Form 2A. And we understand the staff said this week that they want to make sure that if there's new development and new receptors, that those are adequately analyzed. And they will be. This is simply referring to the issues already analyzed and approved and the consultations that occurred for those. And that concludes my testimony. As you're thinking about issues this afternoon, we hope that these will percolate up and be on your list. And for specific language that might facilitate that process, our red lines and witness testimony has some language that you could consider to try to integrate what we've talked about. Thanks very much for the opportunity.
Thank you, Ms. Brodsky, for your testimony. And thank you, Mr. Ratliff, as well, for your testimony. For the record, my video was off because I was eating breakfast, but I was listening to everything you said and I was watching your screen. I think all commissioners are doing that on and off as we try to balance all the things we're doing. At this point, we will open up this witness panel for questions from commissioners. So I've got all of you on the screen. Would anyone like to start off with questions? Commissioner McGowan.
Can you hear me?
Yes.
Thanks for coming in and testifying this morning. I'm curious about the comment about alternative location analysis. And I think what you're inferring is, and I want to make sure I'm not putting words in your mouth, but that it would cause undue work because you might be having to work with folks who don't want to negotiate or do not want to participate. But as a parent of 3 kids, I say often, if you won't know if you don't ask. And so I'm curious to know I feel like some of the point of the alternative location analysis is that there might be another location that wasn't thought about before that would be a better location. But if you don't look at it and you don't try it or ask, you'll never know if that was an opportunity. And so I wondering if you can explain a little more the hesitancy about the alternative location analysis.
Yeah, sure. And thank you for the question, Commissioner. I think those are valid points, 100%. And I think there's two components to the testimony we just gave on alternative location analyses, and they're interrelated. So I don't want to step out over my bounds or get over my skis in terms of what the appropriate ALA looks like in an urban setting, which I do still believe, and I think if you look to the language of the statute, and I think if you look to much of the testimony we've heard so far in this rulemaking, and you look to the filings, you can clearly see where the genesis of the ALA provisions was, where it started. And it's very much, I think, directed at this notion of when you have proposed locations near populated areas, do we have other options to think about? I'll defer to Mr. Antonio, who spoke on Tuesday, who spoke very clearly and gave a really good background on the amount of site work that goes into, the amount of work that goes into identifying proper sites in those types of situations, including negotiations with landowners originally. But then I think you need to balance what you're asking for with the scope of the triggers. So in this instance, we have a few triggers that go far beyond that initial intent of the rule. High priority habitats is a great example, as is the trigger for upgradient of wetlands or riparian corridors. Riparian corridors is not a defined term. We're not even sure what the scope of that trigger could be. So in those situations, you're really targeting these rural areas, many on the western slope. You have one landowner maybe. You might be dealing with federal surface. You might have limited locations. And so I think what we're saying here too is in those situations, it becomes particularly burdensome and maybe not as informative or useful to ask about sites that there's no access already. The operator already knows where their developable locations are on the property they have access to or own or are on federal surface. And so I think our point there is that when you ask, when it's both the scope of the test and the scope of the triggers, and those need to be balanced. And so I don't really want to speak to the exact extent of what the scope of the analysis should be, say in the 500-foot trigger for populated areas. But when you balance it with the current scope of the criteria that will now trigger the ALA, we think the test becomes overly burdensome in that situation and potentially not as useful as the commission would like it to be.
Commissioner McGowan, any follow-up to that? Okay. Other commissioners with questions? Commissioner Gonzalez.
Yeah, I've got a question. I was trying to find the exact language in the rules, and I don't know if I got to the right spot. But I think it was Ms. Brodsky who mentioned that the permit expirations would expire with a cap. And I want to clarify something. Perhaps maybe if staff can jump in here. Do the rules state that the permits will expire when the cap expires, or is it the later of the two? Meaning that if you have a cap and you submit your Form 2A kind of towards the end of that duration, that 2A is good for 3 years, and the cap maybe have a 1-year duration on it, or for so long as there's operations. How do those coordinate in that instance?
I can try to answer that question, Commissioner Gonzalez. This is Attorney General Joel Minor. The intent is for permits subject to the cap to, and if we could get Ms. Stanzik on as well, she can speak to this in more detail, Ms. Larson. But the intent is for permits that are subject to a cap to expire at the same time as the cap itself. So the default expiration rule in 311 would essentially not apply to set the expiration date of those permits. It would be set by the CAP order. So Ms. Stanzik, do you have more to add there? And I can call up the specific rule site if you give me a moment.
What was your question, Joel? Sorry. Hi.
That's
Good
okay.
morning.
Welcome, Ms. Stanzik. Could you explain a little bit more about how the expiration of permits that are subject to a cap will work? So if
Well, it's the same as the expiration as related to the OGDP. When the cap expires, any permits that have not had action taken on them will expire at the expiration of the cap. And without a cap, with simply an OGDP, the same is true.
And Commissioner Gonzalez, I can now direct you to the right site in the rules. So this is Rule 314B2, and I will just go ahead and read it for the record because I think it clearly conveys this concept. So approved oil and gas development plans, drilling and spacing units, Form 2As, and Form 2s within an approved cap will not expire until the cap expires pursuant to Rule 314C, but will expire at the time the cap expires.
That's the rule I was reading. I wasn't sure if there was something else in the 302 series that may have explained different, 302 or 304, wherever the specific permits were. Thank you for the clarification. I think that may be subject to additional discussion at some point. While I have the floor, I'd like to ask a question about caps in particular, for specific to small operators and how they may apply in a beneficial or the way I see it in potential adverse ways. You know, some small operators are big fish in the basin or the field they operate, right? They are the player. Oftentimes they're not. You know, oftentimes you've got a bunch of other operators, either other small operators that are part of the competition, or you have big operators who have established positions in certain fields or basins. And so I'm curious if the Small Operator Society has any concerns with maintaining a competitive presence in areas where they may not be able to put together 45% ownership to form a cap, and other operators may. You know, I would, you know, I envision some potential maybe unintended consequences of having, you know, a duration of 10 years for a cap where the operator may have 45% and is holding up capital, is holding up the ability for another operator to monetize their investment for such a duration of time. And so I'd like to get the Small Operator Society's input on that.
Commissioner Gonzalez, thanks for the question. We heard your questions and comments on this issue the other day, and obviously been thinking about it. You know, at this stage, we're really focused on better incentivizing caps with longer duration and the durability incentives we discussed. We do think caps are an important tool to accomplish some of the goals and for the benefits that have been discussed throughout this rulemaking. And so I'll make one point that on the small operators side, the incentives become even more important because while it was discussed that maybe putting together a plan would only take a few months, it might not cost that much. That could be true for some larger operators that have large internal regulatory programs and are able to spread that cost over, you know, larger developments. But for a small operator, the cost of preparing and developing a cap could be significant. So they need some certainty going into the process. But onto your second point, we do recognize the tension. And we recognize that there are members of the SOS that are in different positions. We have members interested in caps, but because of their positions, the exclusivity is not as big of an issue. And we haven't really spoken to that incentive because it's not as incentivizing for some of our members. And then we have members that have questions and concerns about the cap process and for the reasons you discussed. On the sense of the latter, our indication is that this is potentially more of an issue in the DJ, certain areas of the DJ. And even there, under the CDP framework, we haven't actually seen this play out to date, but it doesn't mean that it won't now, particularly if caps are better incentivized. But we also understand that operators with concerns have voiced that they believe that the objection process, and this was raised the other day, that the objection process in the CAP permitting framework can play a very important role in allowing those operators to voice their concerns, to get their concerns heard, and to potentially incentivize those developing CAPs to proactively engage with those operators and negotiate with them in order to go in to the permitting framework with some agreed upon conditions. Other than that, we don't really have a consensus approach on how to balance these competing tensions. But our focus right now is on the incentivizing of the CAPs.
Thank you.
A sort of follow up to that, and then I'll get to the other commissioners. We had heard yesterday from former Director Lepore the concept of for Western and rural. I think they put it in their brief. The concept of securing operatorship, and kind of a way of dealing with that is to allow an operator to file and then give an opportunity for others to sort of get in the game. And then if others don't get in the game, then sort of set aside that acreage while the CAP is developed. And then we can determine whether we agree with the CAP, et cetera, with an approval. Do you have any response to that sort of process approach? I think what it was trying to get at was doing a CAP is a lot of work, and the incentive of operatorship is important. And so this would sort of establish sort of pretextual operatorship while you're doing the work. I mean, that sort of sounded like a good process to me, and I've not had a chance to speak with the other commissioners about it. But since you're here and talking about CAPs, I thought I'd ask you about it.
On that issue, I think I need to understand and look closer at Mr. Lepore's exact proposal. As we've kind of said a couple times today, our testimony is actually not focused for our members on the incentives related to operatorship. We understand their role in the larger CAP proposal, but we're actually here and focused and thinking about operators, and these exist on the West Slope and in some rural areas in the DJ, where the incentive of operatorship is not sufficient. Because those operators, through lease holdings, private mineral ownership, have what is the equivalent to an exclusive right to operatorship. So that incentive that is a linchpin in the rules as proposed doesn't incentivize those operators. And so we need to think beyond that and think, what other incentives do we have in order to encourage those operators to take advantage of this CAP process and to engage in the long-term landscape level planning and get the benefits that the commission wants out of it and the operators want out of it.
Okay, fair enough. Commissioner McGowan.
Thank you, Mr. Chair. I'm wondering if Mr. Minor or Ms. Danzig could remind me, what is the expiration date currently for a CDP? How long do those last?
I will try to answer that question, but that may actually be a better question for Ms. Larson in her capacity as manager of the hearings unit. My understanding is that the expiration is set on a case-by-case basis in the order, but I am not positive about that. So Ms. Larson or Ms. Stanzik, would either of you like to weigh in?
Yeah, excuse me, this is Ms. Larson. I'm happy to weigh in. Yes, currently CDPs are set, the expiration date is set in the order.
And just out of curiosity, the two that have been approved, you happen off the top of your head to know what the expiration dates were for those?
We can go back and get that information for you. I'll be honest, I don't remember off the top of my head.
And then the way that I read the current draft rules, the operator can ask for an extension for their CAP or their permits before they expire. So even though there's this 5-year window, and so I want to confirm that that's the case. And then if staff maybe could talk a little bit about how onerous is it to ask for an extension of a current permit? Do you have to start all over again and do all the paperwork all over again? Or is it a more streamlined process?
Before we get to the answer to that second part of your question, which I think Ms. Stanzik can probably provide, I do want to correct, current rule, I believe 216G, does provide a default 6-year expiration date for comprehensive drilling plans. However, I believe in practice in one or both of the commission orders creating comprehensive drilling plans, that date may have been changed to sort of meet the unique needs of those plans, which I think reflects the framework that staff has proposed in Rule 314C, which does set a default of 5 years, but the expectation that the operator can propose a different expiration date that could be longer or shorter, depending on the sort of unique nature of each individual comprehensive area plan. So, Ms. Stanzik, would you like to now answer the actual question there?
So, yes, sure. So, Commissioner McGowan, was your question about extension of caps or permits, such as a Form 2, a Form 2A?
Well, so maybe there's a distinction that I maybe need to clarify first, which is, so let's say I applied for a cap and I got a cap, and then I have all of the Form 2s and the drilling and spacing unit, all of those are underneath it. They have a shorter expiration date. If I apply to extend my cap, then do I also have to submit an application to extend those permits underneath the cap? And then so do you see what I'm saying? Like, how many times do I have to submit an extension, and then what kind of work goes into submitting an extension?
So that is one of the incentives of a cap, is the rule that Mr. Minor read, that all the pieces that it takes, the OGDP, drilling and spacing units, 2As and 2s, they all, once they're approved, they will be in effect until the cap expires. So that is an incentive. Rule 311 is talking about OGDPs, DSUs, 2As and 2s outside a cap. And that's where the 3 years of the OGDP is sets the end point for the expiration for those components.
So, sorry, just to clarify for myself and for those who are listening, if I have a cap and I apply to extend the cap, the permits underneath the cap all extend at the same time. Okay.
Yes, that would be our intent.
And sorry, when I ask for an extension, am I starting from ground zero and filling everything out, or do I just update you on my progress? Like, can we talk a little bit about what that looks like? Because it sounds from feedback, from testimony, that people are worried about how much work is involved in doing this.
Yes. Looking at, I guess it's Rule 314C4, it says the commission approves the extension of the cap following a hearing. So I would expect that the applicant, the operator of the cap, files a hearing application just specific for the extension of the cap. And that would be the consideration for the commission.
And I'll just build on what Ms. Stanzik said to note that in addition, Rule 314 C3 provides certain information that operators should include in that hearing request for the cap extension, which both includes, I think includes really two very important components. The first is evidence the operator has diligently pursued mineral development within the cap, and that doesn't mean they have to have drilled every single well they intended to, but certainly there needs to be evidence of, for example, the operator is working towards building the appropriate infrastructure, such as perhaps pipelines or working towards electrification. And then additionally, their operator needs to demonstrate that there have not been significant changes inserted the land use, because obviously a cap of a long duration, say it is 10 years, a lot might have changed on the ground in that area in the past 10 years, and the commission would need to have some information about that as it's weighing the appropriateness of extending the cap during a hearing.
Great. Commissioner Nanjapa?
Thank you, Mr. Chair. And thank you both for your testimony. I'm kind of building on what Commissioner McGowan asked as well, and I appreciate that clarification, Ms. Stanzik, about the cap once approved, that all of the approved OGDPs, et cetera, forms 2 and 2A would all extend for the duration of the cap, which we have now expiring at 5 years, but there can be an opportunity for extension with a hearing and recognizing what AAG Minor just mentioned with respect to what the operator needs to demonstrate. So and then also building on what Commissioner Gonzalez was asking. So if you have a cap and you have, OGDPs and forms 2 and 2As that have been approved at the beginning of the cap, those would go at least those 5 years. If in year 4, you put in some additional OGDPs and forms, those then expire at the 5-year mark unless an extension has been requested. Is that correct?
Yes, that's correct.
Okay, and then that would, so whatever, if an extension was approved for another 5 years, then all of those permits, including those ones in year 1 as well as year 4, would all be continued through
Yes.
the new extension date. Is there any limitation? I didn't think I saw. Is there any limitation on how long an extension can occur?
No.
So the request could be for 10 years.
Mhm. Yes,
Okay.
there's flexibility there for the applicant and for the commission in the decision making.
Okay. Okay, thank you.
Commissioner Messner?
Thank you, Mr. Chairman, and thank you for the testimony. I had some questions about alternative location analysis and kind of your thoughts around that. I continue to hear that the evaluation of alternative locations is standard operating procedure for most operators as far as looking at their efforts towards avoiding minimizing or mitigating impacts to public health, safety, welfare, the environment, wildlife resources. I certainly believe that the intent to do ALAs and standard operating procedure, it sounds like for most operators, is to do ALAs, whether they're in a populated area or not. So I guess I continue to scratch my head as to the concern about doing ALAs if it's already standard operating procedure for operators to do those in order to determine the best site and to do what has been indicated to me as standard operating procedure to look at ways to avoid, minimize, mitigate, and protect for public health, safety, welfare, the environment, and wildlife resources. So maybe you could help me understand why there's a kind of pushback against doing those.
Thank you, Commissioner Messner. I think this is like anytime you engage with like a regulatory framework, right? This is a common question. Well, if you're doing it internally, why not just do it? But I think you always need to balance this notion of, voluntary compliance and imposing a regulatory framework. So I think there is a distinction here that we're making where, say you have a large parcel of property on which you could cite a few different locations, whether you've leased that or whether you own it. Take the West Slope as an example. That landowner, if it's leased, may have only given you a couple of locations that they're willing to cite on. If you own it, you obviously could then potentially cite wherever you would like. And I think the point is that you're correct, and that operators are going to look and they're going to say, look, I don't want to cite in a Army Corps of Engineer regulated wetland and trigger a 404 permit if I don't have to. I don't want to site in high priority habitat if I don't have to. So they are always looking at those options and thinking about what is the best option both to protect and minimize adverse impacts and to develop a pad with some sort of regulatory efficiency. But then you take it another step when you say, please take that internal process and turn it into a formal evaluation process that does cost time, money, effort, particularly for smaller operators. They're going to have to hire outside consultants to prepare all that paperwork, the maps, and the various information that you're requesting. And then to our last point, where I think it's particularly apparent in rural areas, and particularly I think even most on the West Slope, it is true that an operator might not be looking at surface areas that they don't have any rights of access to at the moment. So that adds another overlay for some of these operators.
Commissioner Messner, follow up?
I do not.
Okay. Other questions for this panel from the commissioners? All right. Seeing none, thank you, panel, for your presentation. Thank the Small Operator Society for being involved and for your filings. And we will allow you to be zoomed away, and we will bring on our next panel, which is the public water suppliers. So let's give Ms. Larson a minute or two to adjust our panelists in that regard.
Good morning. I'll be presenting today for the public water suppliers. Can you all hear me?
Yes, we can hear you. Do you have your witnesses with you?
We'll have one witness, Matthew Seitz.
Okay, and I see Matthew's online, so you are good to go. Ms. Larson, how long did they set aside?
They have 10 minutes set aside for this presentation. And Ms. Brownhill, just to confirm, will Mr. Sura or Mr. Mefford be joining you today?
They will not. I believe they're available for questions, but just myself and Matthew Seitz will be presenting. We're hoping to just use 5 minutes.
Okay.
Thank you.
So good morning. My name is Stacy Brownhill. I appear today on behalf of East Cherry Creek Valley Water and Sanitation District and Arapahoe County Water and Wastewater Authority. I'm speaking with the support of the public water suppliers. We're a group of 12 public water supplier parties. And as I said, today we're just using 5 of our minutes to briefly address why we support certain changes in the 300 series. In the 300 series, we requested notice and consultation requirements, and our requests were largely addressed. First, in the latest draft rules, operators must provide notice of a complete application to public water systems that operate a surface water intake within 15 stream miles or water supply wells within half a mile. And second, operators must engage in a formal consultation process with those public water systems. These are 2 very smart changes that we support. Requiring operators to provide notice to and consult with public water systems is in everyone's interest. Operators and public water suppliers alike want to avoid contamination of public water supply. So we support these changes in the 300 series. We urge the Commission to adopt those changes in the final rules. And next, I'll introduce Matthew Seitz. He's a principal hydrogeologist for HRS Water Consultants. He's appearing on behalf of South Adams County Water and Sanitation District, and he's worked in the field of water resources for over 20 years. Mr. Seitz, I'll turn it over to you.
Okay, thank you very much, Stacey. Can everyone hear me okay?
Yes.
Okay, great. Okay, I just have 3 slides and 5 minutes to go through them all, so we'll keep it brief and hopefully have a little time for questions. Yeah, as Stacey mentioned, we do appreciate the pending changes as written that involve public water suppliers in the consultation process, and that leads to the best decisions. Real briefly, here's this red outline here shows South Adams County's Water and Sanitation District service area. This DIA is over in this portion, and you have I-25 and I-70. They provide water in Commerce City and unincorporated Adams County to approximately 50,000 customers. So the relevant local government and proximate local government are, cover portions of their service area, but it's a very good change, in our opinion, that water providers, public water providers, are included in the consultation process. South Adams County's wells are shallow, what are called type 3 wells, and I know you'll hear a lot more about this in the Series 400 rulemaking process, but in essence, that means that these wells are sand and gravel that don't have a low permeability layer above them, such as clay or a shale layer, which would inhibit the vertical migration of a spill. So shallow spills are of particular interest to South Adams County and the Public Water Suppliers Group. In fact, South Adams County has dealt since the 1980s with some VOC spills, not oil and gas related, but at a chem sales site that work's been going on there since 1980. And I saw yesterday CDPHE just came out with another rehabilitation plan. So once the horses left the barn, it's very impactful. These VOC spills from this chem sales site has shut down 2 of South Adams County's most productive water wells at the south end of their system that both used to produce over 2,000 gallons a minute per well. And that really adds tremendous cost. And once there's a spill, particularly in these shallow type 3 type 3 is how the Division of Water Resources classifies them, but they're basically just shallow sand and gravel aquifers from old channels of the Platte River where this sand and gravel has been deposited. They're very prolific, and South Adams relies on them almost exclusively for their water supplies. So very important to use the best local knowledge to consult with industry applicants to make sure that these resources are protected. I tuned in to yesterday's testimony a little bit. Portions of South Adams are in Commerce City, and I thought it was kind of neat the way that Commerce City had collaborated with, I think it was Extraction Oil and Gas, to prepare a heat map that was discussed in yesterday's testimony. And I grabbed a screenshot of that during the testimony and overlaid it with some of these dots of various colors, or where some of South Adams water wells are located. And I just wanted to call attention to, in most cases, we're in agreement with what Commerce City came up with, but there are some wells down here that were in, I think the green area was, more industrial zoning, and in their assessment and the way they weighted the criteria was deemed, favorable for construction of a oil and gas site. The new regulations include for type 3 as proposed, offsets and consultation. And we think that's a very good idea. There's some of these existing water wells that are, in a green area and involving these public water suppliers in here. We have, in the case of South Adams, we have been working for them since our company's founding in 1981. And we have files and groundwater models and all sorts of data, and really the best decisions, like any petroleum geologist, hydrogeologist like myself will tell you the same thing. We need to get the best data on the table, start talking, and that'll improve the background monitoring. It could identify the location of pre-existing problems more accurately, and it'll be more protective for all parties involved, in my opinion. So I thank you for your time. I think basically we are very in favor of Rule 309G as proposed, that involves public water suppliers in the consultation process. So that's, I hope, under 5 minutes. Are there any? Happy to answer any questions.
Great, thank you, Mr. Seitz. If you could unshare your screen, it'll make it easier for me to see everybody.
Okay.
Great, there we go. Okay, at this point, we have questions from commissioners, if there are any, for the panel from public water suppliers. Okay, I'm not seeing any questions, which meant you did your job well. So appreciate, again, the testimony and evidence presented this morning. We will continue forward with taking our next panel, and we will zoom you away and bring to the panel Weld County for its presentation. Okay, I see Mr. Barker and Mr. Maxey, as well as Kurt Moore. Welcome you all to our proceedings. Hello, Jason, see you visually. See Mr. Moore.
Good morning.
Good morning.
I think Bruce was going to kick it off.
Okay, let's give Bruce a sec to, I don't know if he wants to visually appear or not, his pleasure. At this point, Mr. Barker, you're still muted on our end, actually. Ms. Larson, if we could unmute Mr. Barker. Oh, there we go. Ms. Larson, let's unmute Mr. Barker one more time.
He has actually the ability to mute and unmute himself. We haven't muted him here.
Oh, okay. Mr. Maxey, are you in proximity to Mr. Barker?
Unfortunately, no, sir. He's up at his office and I'm in mine. You know, I think it looks like he's continuing to try to connect here. If it doesn't work in the next couple seconds, then we'll just go ahead and start off.
Mr. Maxey, since we're waiting on Mr. Barker, I'm going to call an audible, and I'm going to take a 3-minute break for all of us, and that will give him a chance to get on board. So we'll be back at 10:20. It's 10:17, and hopefully we'll give him a little 3 minutes.
Thank you, sir.
Okay, it's 10:20. We're back live. Were we able to get Mr. Barker to participate?
Chairman Robbins, it does not appear that Mr. Barker was able to connect audio. No matter how many times you test out systems, it never ceases to fail, that sometimes you have little glitches. So, you know, I think he was just going to do some introductions real quick and say basically 30 seconds worth of items before myself and Kurt Moore got into our presentation. So I think we're okay.
Okay, it's entirely up to you. We're happy to, you know, defer so that we can allow your entire contingent to participate, or if you want to put on your best Bruce Barker accent and pretend like you're him and do the intro. I totally want to defer to you. Your voice is a very important voice in this process, so I want to make sure that we hear you.
I appreciate that, Chairman Robbins, very much. And again, I think that we should be good to go. I was able to call him and verify that we're able to proceed if he's not able to join. So I think we're okay. And as Bruce and some of my staff have heard me say many times, I'm not an attorney, but I do play one on TV. So I think we're okay to proceed.
All right.
All right. Well, good morning, commissioners. Some of you might know me. My name is Jason Maxey. I'm the director for the Weld County Oil and Gas Energy Department. And I really appreciate and thank you for your time this morning listening to our testimony. As Chairman Robbins mentioned earlier this morning, you have already heard a lot of testimony over the last few days, and you've seen a lot of presentations. And some of them have been gone over so quickly, it's hard for me to keep up, and I'm sure it's hard for you all to keep up and keep straight as well. So instead of showing PowerPoints and graphs, Hearing Officer Kurt Moore and I simply wanted to talk with you this morning. You've already received our many pages of testimony that we submitted, but we wanted to speak about it, just a few key points regarding the Weld County process and how we look at oil and gas development in our county. So after Senate Bill 181 was signed into law, it's important to note that Weld County did not wait to react. Oil and gas is an important part of our local, state, and national economy. And being the #1 producing county in the state and the county with the most permitting activity, our county commissioners wanted to make sure we did what we could within the boundaries of the rules to ensure oil and gas development continues while also being protective of the health, safety, welfare of our residents and the environment. So what did our commissioners do? Our commissioners enacted 1041 authority over oil and gas mineral resources in unincorporated Weld County and designated them as an area and activity of state interest. The commissioners created a brand new department in July 2019, which is the Oil and Gas Energy Department, or OGED as we refer to it, staffed with 12 full-time people whose sole responsibility is the permitting and regulation of new oil and gas locations. And the commissioners implemented a new 1041 WOGLA code, which was effective in August 2019, which is the basis of how new permits are reviewed and decided upon. In fact, we just got done with a thorough revisions of our rules to further strengthen them and enhance our permitting process. It's important for you all to know just a few key points about our process. I have 3 of them for you this morning. First off, alternate location analysis, or as we call it, site analysis. That has been a topic of many questions and much discussion. Matt Sura gave an example in Commerce City, and I want to make mention that that was a good example. And it showed how local government and the operator, working on land use issues together, could come to agreeable terms that worked for both parties. In fact, it wasn't a good example, it was a great example of how that process should work. What I want you all to know right off the bat is Weld County performs a site analysis, or an ALA, for every location. Every location. Some site analysis are more in depth than others, but they are all done for all locations. So the example I want to give you real quick is if you're in the middle of a large ranch in Weld County, that location analysis might be a little bit different because you have a large acreage, no homes nearby, you have a willing landowner, you have a surface use agreement in place, but we still ask and look into other locations to deal with site analysis as well as cumulative impacts. Contrary to that, if we have a location that is closer to receptors, it's a more thorough, in-depth analysis for multiple locations. And we don't base this off of triggers. It's embedded in our process. The second thing I want to mention is that we have multiple on-ramps or milestones for the COGCC to be included in our process from the beginning to the end. In fact, there are 4 different opportunities for the COGCC to interact with Weld County. These are clearly laid out in our code, and I want to stress the importance of the COGCC being a part of these milestones and providing substantive input. This is important because it will help identify any issues or concerns well in advance of Weld County getting a formal permit from the operator. It'll help prepare the operators for what they need to address in their application. It will give them a little more certainty regarding the permitting process and knowing that something hopefully won't come up at the 9th hour. And it'll also help Weld County and the state with better planning and knowing well in advance the operator's plans for an area. Having the COGCC be a part of our pre-application process, as well as these other milestones, will help eliminate conflict. The third point is multiple items the COGCC is considering to require of operators are already handled in Weld County through our 1041 WOGLA, or Weld Oil and Gas Location Assessment process. Access points, haul routes, light and noise mitigation, floodplain permits, emergency action plans, which include first responders and our Office of Emergency Management, drainage plans, notification and referral requests of multiple agencies, not only including the COGCC, but also the CDPHE, the CPW, other jurisdictions within our notification zone, such as towns, counties, fire districts, school districts, etc. That is a part of our process from top to bottom. So in conclusion, what I just want to say is when considering the proposed rules before you, we would encourage you to absolutely defer to a local government, such as Weld County, who has enacted rules and regulations as robust as ours, and which include the COGCC throughout the process. there should be no reason why the state would not agree with the location and permit we are considering, especially with the partnership that we have included in our rules and regulations and having so many opportunities for the COGCC to partner with us as we're evaluating those permits, along with the operators. So I'd like to thank you for your time for my few minutes talking to you, and I'd be happy to answer any questions after Hearing Officer Kurt Moore is finished with his time. Thank you.
Thank you, Mr. Maxey. Mr. Moore, we look forward to hearing from you.
Yes, can you hear me? Can you hear me? Okay, thank you. Well, again, I'd like to thank the chairman and the commissioners for the opportunity to speak today, and the staff. I know you've all had a lot going on, a lot to consider, so I'll try to be brief in my remarks and just build on what Director Maxey said. You know, I'm the hearing officer for Weld County's Oil and Gas Energy Department. So all the work that is done by Jason and his team will come to me when they find an application complete and ready to set up for a hearing. Up until then, I have really no idea what they're working on. But when a hearing is set up, you know, I will review the application, and I'll eventually, right before the hearing, I'll get a staff report, and I'll start reviewing all of that. But I want to be sure to hit on what Director Maxey said about the alternative location analysis. At hearing, you know, the applicant testimony, the first thing I want to hear from the applicant is they're on the application site is the best site that could be considered. And Director Maxey said it well. If the area that they're in is what I would call pretty quiet, in a pretty remote area of Weld County, that's going to be less rigorous alternative location analysis. But even then, I will have questions for the applicant, you know, considering their spacing unit and where their proposed site is. Is there another site nearby that's already disturbed? Could you be on that site? I do want to, at the end of the day, you know, I'm going to make a ruling on if this site protects public health, safety, environment, and wildlife resources. I want to at least start with knowing that they picked the best site. And if I'm uncertain about that in taking testimony, the process is going to go on. And if it gets to a point where, you know, I honestly don't believe that they've exhausted that analysis and there may be a better site out there and they've not fully considered that, I have continued hearings to order that applicant to go back and consider. Because again, I want to end up at the best site that best protects public health, safety, environment, and wildlife. Coupled with that is testimony taken from the applicants around cumulative impact analysis. So if I can come to the conclusion that they're at the best site, the next testimony I'm going to take is all about what is your application doing to mitigate impacts and not aggregate and accumulate and build on impacts. I think initially I was pulling that out of applicants, but I think applicants have modeled their applications and they're more forthcoming with telling me those types of things. But generally, things that would give me comfort that there is a cumulative impact analysis going on inside of each of these applications would be matters such as, here and offer some more, we're going to deliver fresh water to this pad with pipelines, and that's going to significantly reduce truck traffic and noise and dust. And here in Officer Moore, in addition to that, we're going to transport crude oil and produced water off of this side, which also will significantly reduce truck traffic. In the alternative location analysis, I may be wondering, well, why did you pick this site? There's 2 building units within the notice zone there, and there's a couple on the haul route. That testimony around mitigating those impacts could be compelling to a hearing officer to know that although there is a building unit or 2 building units in the notice zone, hearing officer Moore, one of those building units is a surface owner, and we've notified and met with all of the other building units, even building unit owners that are out of the notice zone. And upon describing our application and describing these cumulative impact analysis techniques we're doing, we believe we are adequately mitigating the impacts to public health, safety, environment, and wildlife. So then it becomes the hearing officer is taking testimony. I'm weighing what I've learned by reviewing the application and the staff report and various referral agency comments, considering the conditions of approval and the development standards. And at the end of the day, the hearing officer is going to have to render a decision. A, is the site in compliance with the code, the development standards in the code? B, is the applicant going to be in compliance with the condition of approval in both the staff report and any referral agency responses? But at the end of the day, I'm weighing whether this application is going to adequately protect public health, safety, environment, and wildlife. And I take that very seriously. And in addition to that, I think I also have to kind of put on my planning hat to be sure that there's a compatibility checkbox done there. I mean, is this site compatible with surrounding and adjacent land uses? So that's generally the process that a hearing will go through. I think it's worth noting that the referral agencies that are notified as part of the process done by Jason's team is very helpful to a hearing officer. I'm very hopeful that this process will better engage the COGCC staff with Jason's staff so that we're not trying to do two permits separately. We can hopefully get to the point where we do one permit together. And I do want to give a shout out of sorts to Sean Hackett in the CDPHE. The referral comments from the Colorado Department of Health and Environment are very complete. They're very well organized. And in my testimony that I take, the testimony that I take from the applicants, I embed a fair amount of that CDPHE referral comments into that application. So with that, it looks like we might be over our time, and I apologize for that, but I would certainly be willing to answer any questions you might have.
Thank you, Mr. Moore, for that testimony, as well as Mr. Maxey for your testimony. It is greatly appreciated by the commission. At this point, we have an opportunity for commissioners who may have questions for either of you. I'll first turn to Commissioner Nanjapa.
Thank you very much, Mr. Chair, and thank you both for your testimony today. I appreciate what you described in your process. It seems quite thorough. Is this process clearly outlined in the new county regulations that you mentioned that you recently revised?
Commissioner Nanjapa, yes, thank you very much for that question. And yes, it is absolutely clearly outlined. I do want to make one point of clarification potentially, and that is this process and these milestones, so to speak, that I mentioned earlier, three of the four were included in the first 1041 WOGLA code that was passed a little over a year ago. So we've been operating with the three of those four milestones for over a year now. The one that was just added, which we consider to be better planning for the operators, for the county, for the state, is the advent of our pre-application meeting, which is a requirement of all operators to have with Weld County prior to them sending out their required notice to surrounding entities that are clearly listed in our code. The COGCC at that pre-application meeting, it is clearly outlined that they are a required invitee for that process to kick it all off. Now, whether or not the COGCC determines to be a part of that process and to work through those milestones with Weld County, that is up to you all to decide. But it is very clearly laid out, and I want to make note that the COGCC, it's not a Weld County will invite them if we want to. It is the COGCC is a required attendee at that pre-app meeting to kick this all off so that we can start taking a look at the items which will allow for development and which will also protect the health, safety, and welfare of our residents and the environment. We find that very critical.
And just as a quick follow-up, and I know I'm somewhat repeating myself here, but all of those different steps that Mr. Moore, that you were going through, that you do, and all the questions that you ask, that's part of what is laid out in your regulations? Is that correct?
That's correct. And thank you for the question. It's good to note that I want to be very, very consistent in these hearings. I want to be sure that the applicants know how to prepare for these hearings and know what type of testimony they need to give. Some are perhaps better than others, but regardless of who's before me, I am going to drive out what I need to find so that I can order what I need to order. But yes, the components that were described here are embedded in the code. I do want to stay in the four corners of the code as finding compliance with the code.
Okay, thank you. And then last question is, so then the ask, if I'm understanding correctly, is that because of this, you would prefer, are you preferring sort of a sequential process where the operator comes to you first, and if you approve, then you would like to see COGCC just adopt that approval? Is that the ask?
I'll take a swing at that, Jason. Yes, that we believe that the process embedded in our code would drive out, whether it's a rural location or a more urban location located in Weld County. We believe that Weld County and the state staff would come to the same conclusions. It's kind of like if we were both concerned, if there was an application to put a pipeline in the ground and it was in a pipeline corridor and there's already a lot of pipelines in there, and is there room for another pipeline? The only way we're going to know is to pothole and dig that up and look at all those pipelines. We think we can dig the hole, and we think we can include the state staff as much as they want to be included in that exposure of the pipelines to determine if an oil and gas location is appropriate here or a pipeline is appropriate in this strange analogy I'm dreaming up. But I don't believe it's necessary for the state to dig a hole adjacent to the hole that we're digging to try to come up with the same outcomes, if that makes sense.
Thank you very much.
Commissioner Messner.
Thank you, Mr. Chair, and thank you both for explaining that process. I do appreciate the process and the regulations that have been put into place. Just a little bit of a follow-up to Commissioner Njapa's questions, and just so that I'm clear, it sounds like the process that ideally Weld County would follow based on your comments would be kind of a modified sequential process, understanding that we've got in the regulations two different opportunities for review. One is a concurrent review, one is a sequential review, and also provisions in there for substantially equivalent information to be provided in order to inform the state's review process, which is a co-equal independent review process, but based on the information that you all are sharing right now, there's a significant amount of probably substantially equivalent information that would be provided by your local process. And so you guys are good with the rules as written right now based on kind of that review process?
If I could maybe take the first swing at that one, Commissioner, thank you very much, Commissioner Messner, for that question. And then if Hearing Officer Moore would like to add to it, then please do so. I think that it's more of a recognition of local government deferment, acknowledging the fact of how robust and wholesome our process is. And again, it's almost a combination of the two, because you have the concurrent process and you have the sequential process that are outlined in your proposed rules. And I think through what we've described about Weld County's process, not only on my team and what we do leading up to a hearing, but also through Hearing Officer Moore's process at the hearing, there are multiple times, again, to where the state can interact. And so that is that concurrent process. But if we go through the complete process and approve a location, then the sequential part would be for the state to say, we acknowledge that we had all these times to participate. We did participate. We haven't had any issues throughout this whole process. Therefore, if the operator needs to submit a permit to the state, it's simply a checkbox because you've been along with us for the ride the entire time. It's kind of a blended approach, I guess, in my opinion. Hearing Officer Moore, I don't know if you.
No, I think that's right, Director Maxey. And again, appreciate the question, Commissioner Messner. I think the end game here is the vast majority of sites that are going to come to the hearing officer in Weld County are not likely going to have too much heat associated with them. I think the state staff, as Director Maxey has outlined, is included all the way into the pre-app meeting. I work closely with Ms. Stanzik and Mr. Duranlo through the years. I'm sure their staff could quickly come to a conclusion that this is a pretty cool location in northern Weld County and just monitor that until it gets to the finish line with plenty of opportunities to say, hey, slow down. I'm worried about this potential impact or that potential impact. But again, I think the vast majority of the sites that have come before me in the last year, I don't believe the state staff would find anything different than what Jason's staff and what the hearing officer are finding. And in fact, I believe the 1041 WOGLA permit includes a fair amount of things that the state doesn't do or perhaps wouldn't do better, such as access points off of county roads and haul routes designed between the applicant and Weld County Public Works, which is roads and bridges, entering into road maintenance agreements with Weld County Public Works. There's a fair amount of land use interaction in there that I just think that Weld County is better positioned to control and manage that and transparently share that with the staff as they go. If we get into a yellow or a red or more heated permit, I think there'd be a lot more interaction. I think for industry's standpoint, not that I'm here testifying on behalf of industry, I think what everyone's trying to avoid is Moore came up with that and the state came up with that, and it creates a diverged permit. We don't believe that we're positioned to do that. We believe that the inclusion of the state during the process as designed by the county would avoid that.
And I appreciate that. And I mean, I do think that coordination, collaboration, communication between the state and the county through the review process is really important. And I guess, as I read the draft rules, I'm seeing that is, encouraged and supported, within the draft language as far as that communication and, the inclusion of terms like substantially equivalent information certainly, helps in that concurrent review or even a modified sequential, depending on, how each local government wants to do it. And so I guess my question is, I hear what you're wanting. I hear, the goals. It seems to me that the draft rules allow for exactly what you want. And so are we good with the draft rules?
I think we're good with, thank you, Commissioner. Sorry for that. This is Jason Maxey again. I think we're good with parts and pieces of the draft rules, but there's too many, we described the process at Weld County and the on-ramps for the COGCC to partner with us and be a part of the process to try to ferret out these items that might be issues, right? There's a lot of points in the draft rules that give a lot of off-ramps for the COGCC to derail something that we potentially have been working on for months at a time with the operators, with the state, to try to come up with solutions to maybe common problems, maybe problems that Weld County sees that to Kurt Moore's point, maybe that the state doesn't even evaluate. I think that, so there's certain rules that we agree with. There's a couple, 301F would be one that we maybe support, 304E again would be one. But in light of both of these rules, that there are part and pieces that we can agree with. There is a lot of off-ramps also for the COGCC to do what Mr. Moore just said, which is to say, we have now identified something that is a issue, and therefore it's an off-ramp for the state to say, Weld County's location that they approved is not appropriate. And we think that throughout the process that we've implemented and that we are trying to partner with the state on, and the multiple opportunities for collaborative information to happen and to pass between our agencies, that should not be able to happen. If we've gone through that process, there should not be that 9th hour decision that says, wait a minute, we found something that we have a problem with, because you've partnered with us the whole way through. So while we agree with part and pieces of the rules, overwhelmingly, there's a lot of off ramps also that we do not agree with.
Mr.
Go ahead.
If I could follow up, Mr. Maxey, first, I want to thank you and Weld County for the positive and sort of collaborative approach with your testimony today. You've steered away from the sort of lawyering and winners and losers. And I personally want to thank you for that, because I think that's what we're trying to focus in on here at Commission, or at least that's what I'm trying to focus in on as one member of this commission. I'll be interested to have debate and discussion with my commissioners later today about where we're going. I acknowledge that there remain within the rule scheme as set forth by staff areas in which there can be hiccups between a local government and state. I think that the staff's draft is in large part a good draft. I kind of want to say to the world that you got to understand that the state draft is trying to be a fluid document that accommodates your community's approach, as well as accommodating other communities that have maybe a different approach. And so it has to be more of a sort of a higher level approach, because if we get too stuck in the weeds, we're going to be doing something that doesn't really work at all for you, or maybe doesn't work for a community that looks at it from a different perspective. And I think that we've got to, wherever we land at the state, we've got to give it a shot. I mean, I think that it's the practice, the as applied sort of, the state is coming up to Weld County and being involved in your process early on. I think that's, we got to get through that. And, I think back to my time as director, where we, recognized your 1041 pivot, and we embraced it, and we entered into an MOU with you, a document that I signed and your commissioners signed to understand the co-regulatory relationship. And I think it's that kind of thing that we've got to further develop. And as I see it, 181 is a sea change for local governments and for commission in terms of creating co or dual regulatory environments, and framing them through rulemaking is hard. And framing them through rulemaking in a manner that is conducive to all local governments across the state, as well as the state agency, is also difficult. But I think we're starting to get to the right framework. And I'm looking forward to Commission being fully involved in your process. As Hearing Officer Moore mentioned, I truly think that the vast majority of permits, as we've seen through objective criteria permitting, are green. They're not problematic. But I hope that Commission involvement, no matter how we end up with rulemaking, early on at Weld County and other local governments, will identify those that are red, so that we can identify early on and avoid the sort of hiccups that could exist if we're not working, whether it's concurrent sequentially, whether it's concurrently, whatever it may be. So I guess I don't really have a question, but I did want to make those statements, and I'm going to end where I started, which is thank you to your community for the positive approach to your testimony today. It is heartfeltly appreciated. Other questions? Commissioner Gonzalez.
Yeah. Hey, good morning. Thank you for your testimony. I can tell you my experience that I've seen, the WOGL is not a rubber stamp, as we may have heard from some other testimony over the last couple of days. And I appreciate, the nature of that and the in-depth look that you guys take. I think one thing that's important to point out, because we've heard this from multiple municipalities and local governments who have come before us in the last couple of days, is that it's not up to the commission to insert itself in this concurrent process. It's up to the operator, right? I mean, the operator's in charge of their timing, the operator's in charge of how they go about it, and that's the way the rule's written, to have that optionality. So when we think about that, if the operator wants to take a sequential approach, they're at the risk of having that 11th hour wrench thrown in, or that change that may not be anticipated. Do you guys see the rule written that same way? I'm curious about some of the comments we've had that kind of seem to direct the commission to insert itself into this process.
Thank you, Commissioner. I was pausing for a second to see if Hearing Officer Moore might want to jump in, but since it deals with process, I'll take a first swing at it. I appreciate the approach and the question. And I do agree with you. There's been multiple times throughout the last year after implementing our 1041 process to where I've personally encouraged some of the operators to go ahead and go through the local process first before they approach the COGCC with permitting, because it just makes a lot of sense in a way. We're digging in deep. We're looking at the issues that are important to Weld County and to our citizens. And we want to make sure that that gets buttoned down. I think that the concurrent process, to your point, does allow for some of the potential for different submittals to potentially cause different items to rise to the surface at different agencies, which could further potential confusion. And again, I'll just mention, and I really appreciate Chairman Robbins' comments a minute ago. I want to focus on the collaborative effort of it. And again, those items, to your point, should not come up due to the fact that our process is a hybrid, I believe, of what you all are reviewing and thinking about, and that there can be that collaboration throughout the process up front with Weld County. And then the sequential nature would be that, again, if they have to submit a permit to the state, that the state would fully know that they've been a part of it all the way through. So I do agree with you. I think that the concurrent process, as far as doing two completely separate permits to two different agencies, can pose some potential issues. And I would encourage, again, that cooperation between the COGCC, Weld County, and the operators to eliminate those whenever possible.
Thank you for that, Mr. Maxey. Commissioner Nanjapa.
Thank you, Mr. Chair. Yeah, just a couple of quick follow-ups. I appreciate what you're discussing in terms of this ideal process that you're hoping to get to. And so just curious, if in the instance where you have, the commission is part of the participation, they're engaged, maybe there are aspects you're going along and everything you're in agreement. What happens if there's something where the state says, we just can't move forward with this. This is just unworkable. Do you just engage in a back and forth process? Would you potentially entertain a new location at that point? What would happen?
Thank you, Commissioner. Mr. Moore, if you don't mind, let me talk about the process real quick, but then I definitely want him to hit on the hearing aspect of it, because that's a very, very critical part of our process before anything is determined. So again, with all the different milestones that are in the Weld County process and that are embedded in that and again, it's not just the COGCC. We encourage dialogue with multiple entities at varying levels throughout the entire process. So throughout that process, if Weld County does not identify an issue and the COGCC is at our pre-application meeting, or the COGCC receives the 1041 WOGLA notice, which is the second milestone of our process, and if some red flag goes off in somebody's mind during the review that got missed at the pre-app meeting, there is definitely time built in. There are considerations that can be made. Again, we're trying to identify those things before a formal application gets submitted, because at that time, we hope to have reviewed the locations and the alternates in enough detail to come to a conclusion, to Hearing Officer Moore's point earlier on, that they are submitting an application that already they know is the best location out of the other alternates. So at that point, there are still opportunities, though, for the COGCC to say, we have a question, we have a problem here. We send out referrals to you all and to multiple other agencies for comments back. The COGCC can have a standing a participation level in the hearings in front of Mr. Moore. If they do not feel that me and my staff have adequately reviewed permits for these locations, they can come and participate in the hearings and verbally be a part of Mr. Moore's process and his consideration about what to do with that permit. So at that point, I'd hand it off maybe to Mr. Moore to describe his process a little bit, but hopefully that helps on the front end.
Yeah, that's right. And what Jason just described there, a ton of what's going on in what Jason just described there, I'm oblivious to until there's a hearing. So hopefully the collaborative efforts between WELD and state staff can, smooth out those types of wrinkles. But certainly when it comes to me and there's a hearing, if there's still a wrinkle or there's still some edges to this, I would want to hear testimony. I'll take testimony from some party at the COGCC, and I'm going to weigh that as evidence. And, at the end of the day, this job can be a little bit daunting because there's a lot of things for a hearing officer to consider in the application and the staff report as evidence. And then I've had a hearing that took 4 hours, and for one guy to try to maneuver around and taking 4 hours of testimony, that can be a little bit of a challenge. But at the end of the day, I'm going to have to weigh, is this application best protecting public health, safety, environment, and wildlife? And is it compatible to adjacent and surrounding land uses? And I can't hypothetically say what might happen, but if I'm not satisfied in the commission's testimony puts the thumb on the scale of don't approve this, I would imagine I would deny the application.
Appreciate that. Thank you for helping me kind of better understand how that would work. So the last thing I had a question about is obviously in the current rules, we have an emphasis on DI communities and considerations therein. Do you have something that addresses that in your county level regulations?
Thank you, Commissioner Nanjapa, for that question as well. And the flat out answer is no, we don't. And I'll tell you why. Again, it's a reiteration of what we've said before, and I know you and everybody else is listening hard to this. We look at alternative locations no matter where they're at, no matter who they impact. We just don't look at a potential disproportionately impacted community versus a single family home that's out in rural Weld County or a school or wherever it might be. We look at each and every location on a very site specific basis. We employ good land use technique and processes to come to the best determination for the application that is in front of us. So in that regard, we don't want to view it as who's disproportionately impacted compared to anybody else. We look at all Weld County as being impacted the same, and we want to make good land use decisions, healthy land use decisions for Weld County and our residents.
I would just add to that. It's a great question. Would add to that, Commissioner Nanjapa, that's probably a very good example of where a member of the COGC staff could be raising their hand if they felt that there was a disproportionately impacted community coming forward inside of a 1041 WOGA application. That could be happening at the pre-app, it could be happening at the app, it could be happening all the way into the hearing. I think that's just an excellent example of where the state, if that was a flag that was raising or a light that was going on, the state could deliver that as a concern to the WELD process, and it would be considered at hearing for sure.
Thank you. Appreciate it.
Commissioner Messner.
Thank you, Mr. Chair. And thank you, Mr. Maxey, about the kind of indicating that, every single application goes through an ALA at Weld County. And I guess I'm curious about your experience. Do you get any blowback from operators as far as having to do an ALA for every single application, or does that seem to be no big deal?
Thank you, Commissioner Messner. I think it's important to know what the expectations are when you're looking at alternate sites. We definitely don't go to one end of the spectrum and require operators to go out and do, 4 alternatives, and they all have to have predetermined agreements and surface use agreements in place. And then therefore in our process, Weld County gets to decide which one of those we think works best. Again, the burden of proof for any land use application is on the applicant. Former county commissioner, I know you know that. The burden of proof is on the applicant. What we do expect is that there be a thorough review and answers from the operator, because as soon as we get that pre-app meeting, as soon as we get that 1041 WOGLA notice, that is the second step, we have already had discussions with the operator about, we see what you're theoretically proposing and we see what your number one choice is. Tell us about over here. Tell us about over here. We go out and we do a site inspection as part of our process, so that we as staff can see the topography of the ground. We can see how close visually the nearest homeowner is, or the nearest receptor, whatever that receptor might be. And so throughout that process, do the operators kind of dig their heels in a little bit and say, this is over excessive? I think the answer is no, knowing that we're not saying you have to go out and have predetermined agreements worked out for every location so that we can make a choice. What we're asking them to do is do their due diligence and walk us home about why their proposed location makes the most sense. But we still have those conversations about other areas that are around their drilling and spacing unit, or that area in particular, wherever it might be. And so those conversations do happen, they do come out. But I want to make sure that it's clear about what we require and what we don't, because I heard prior a concern about operators having to negotiate with multiple landowners and having multiple SUAs. That's not what we're looking for necessarily, but we are looking for reasonable, rational answers about why it can't be located somewhere else, and whether it be technical or economical, or whether it's a close receptor, things like that. Again, we're employing land use practices and techniques to help through that determination with the operator, so that we understand and that we can get behind whatever staff report my staff writes up to prepare for the hearing officer, because it's our recommendation if we think that it's good land use and if it's good compatibility. I mean, we have skin in the game too. We don't want to recommend anything to him that does not make good land use and that's not protective of the residents and the environment. So I hope that answers your question that you just asked. Please tell me if it did not.
Let me just jump in there too. It's a great question, Commissioner Messner. I think an example might work or might help you understand. I've been at hearing before where an operator owns the surface, and I think that's a good idea to protect risk. To just own the surface instead of enter into a surface use agreement. But if I'm poking around and rooting around on, well, why is that the best site? It seems like it's got some heat. And well, what about this site over here? It seems like that one's pretty quiet. If I hear things like, well, I bought the surface, so I really don't want to go over on the other side, that's not going to be very compelling evidence to take at hearing. That I'm predetermining and I'm trying to push my way onto an otherwise yellow location potentially, when there's a green location over here on the other side of the DSU. I just don't own the land over there. So I guess my testimony would be at hearing, I'm going to root around in there. And to answer your question, I think early on, I think operators that were coming before me just weren't expecting the level of alternative location analysis that was going to happen at hearing. Over the course of time, the applications that are coming are very robust alternative location analysis slides, but I still ask a ton of questions because, again, I want to be sure if I'm being asked to approve this permit across the filters of protecting public health, safety, environment, and wildlife resources, I want to be sure that we're on the best site and we're not just trying to mitigate at a higher level on maybe the not best side or the second best side, if that answers your question.
Oh, I appreciate that. Thank you.
Thank you. I appreciate that as well. Do we have other questions for this panel? Okay, I'm not seeing any. Again, I express my positive appreciation to you for your approach today. And I personally look forward to getting a regulatory regime in place at Commission. And I look forward to Commission staff and commissioners being involved in your process. I look forward to the next 6-9 months. And, then I want to do a check-in with Commission and with your community to check in with each other and sort of see how it's going and see how it's doing and look at successes. I think that obviously there will be times when there's not successes, and it'll be good to work through those as well, sort of the red ones. So thank this panel for your presentation. Thank you for your filings. And with that, we will zoom you away from the panel and we'll bring on our next panel.
Thank you very much, Commissioner.
Thank you. Wildlife and Biological Resources Coalition is next. While we get this panel up, I want to remind all parties that following this panel, and it may be after lunch, depending upon timing, we need to figure that out. But the next step would be closing statements from parties on the 300 series. Some of you have reserved time for closing statements. We're not sure whether you desire to do closing statements with some of that reserved time. If you could email Ms. Larson whether you plan on doing closing statements, it would help us facilitate process so that we know who's going and how much time. That would be very helpful. I believe Ms. Larson has already emailed all stakeholders this same request, but I just wanted to verbally make that to the group. Having done that, I believe I've given the Wildlife and Biological Resource Coalition an opportunity to join us. And I see Mr. Leif, I don't know how to pronounce your last name, Brad, and I see Mr. Teropoulos. So we look forward to hearing from you.
All right, thank you. Oh, sorry. I'll go first, Brad. And the camera was on yesterday. For some reason, I've got the still photo today. If that's okay, I'll proceed. This is Mike Teropoulos.
That's fine, Mr. Teropoulos. We look forward to hearing from you.
Thanks, Jeff. Can I do a screen share?
Of course.
Let me see now. Screen, there it is, share screen. That's coming up?
Yes, we have your screen share with your PowerPoint.
Okay, great. I'll go first. Brad Clefane will go next, and I'll sum up. We might take a few minutes out of our 600 series allocation. Mike Teropoulos, I'm the attorney for the Wildlife and Biological.
Mr. Teropoulos, you may want to put your screen on without the notes, because I can see your note about this not being your first rulemaking rodeo.
Yeah.
Which I agree with, but you may not want me to see all your notes.
Now I've got to figure out how to kill that.
We'll give you time. Take your time.
Okay. Oh my. I've done this before. Layout.
Mr. Teropoulos, if you'd like to go to presentation mode, you can do that by going to the very top bar there in orange, and there's that screen with the arrow in the center.
Yeah.
That will put you in presentation mode if you'd like to do that. If you go to your left, over one more. Oh, to your right.
Nope. Closer.
This one here.
That one. Yeah.
There we go.
There you go.
Okay. So enough of the not, it's not my first rate rodeo. First thing I just want to touch on is what the stakes are here. And if Colorado gets this right, we'll be an international leader in lighting the way for a just transition to a clean energy economy. If we don't, some might say look out the window this summer in August 2020. So let's get it right for the future and for people and the environment, which we can agree are Colorado's best, most enduring assets. What is mission change and the scope of this rulemaking? We presented mission change as a paradigm shift, amendments to the Act under 181. Legislative sponsors have called mission change a sea change. The governor called it landmark oil and gas legislation. It's been called an overhaul. It's been called a new way of doing business. Protection comes first now, and one of the main points we're making is where warranted, not drilling. And not drilling where there's no safe location for wildlife or where and when cumulative impacts are too great. And that might feed into climate change. So mission change and the impetus behind 181. As we all know, the status quo led to fatalities in Firestone, ballot measures statewide, and continues to fuel the loss of priority habitat and biodiversity statewide and producing basins. And there's pressure to move to new basins every year. Paradigm shift in 5 words or less. People and protections are paramount. Avoidance is one of the key themes that we're going to be stressing throughout all the sections, all our testimony leading up to 1200. Denials, leaving resources undeveloped are not waste if denial protects 181 values, including wildlife and biological resources. And this is pursuant to the Act and a statement of basis and purpose. We really like alternative location analysis in the rules. And just to sum up the support over it this first week of hearings, one of the industry witnesses in the first session, we have to do it. It's been called standing operating procedure. Adams requires ALA for all wells. Mr. Sura called it a useful tool to avoid impacts. Sam Miguel, alternative location analysis and cumulative impacts analysis should be ubiquitous. Commissioner Messner, strong tool for regulatory entities. The goal is avoiding and minimizing adverse impacts. We want to focus on avoiding high priority habitat and focus the analysis on minimizing offsite adverse impacts. And this will be my last slide before I turn it over to Brad. Just to summarize, so what we're looking for in the 300 series, comprehensive permitting processes premised on avoiding the 181 values. For wildlife and biological resources, permitting informed by CNHP, Colorado Natural Heritage Program data, and public comment on caps, leading to better decisions for better protecting 181 values. ALA and CIA, rigorous analysis where the values are present, and defining biological resources in the 1200 series so we know what's being avoided and protected. Over to you, Brad. Unmute, my friend.
All right. Let's see if I can share my screen. No, Mike, you have to unshare yours.
So let me go back. There you go, Brad.
There we go. All right, thank you very much. I no longer can see anyone, but I guess that's okay. Thank you for the opportunity to testify. My name is Brad Clefane. I live in Denver. I also lived on the Western Slope for 5 years in the early 1980s, where I made, I believe, the first county sighting of the Colorado hookless cactus in Delta County. And that is a threatened cactus by USFS, FWS. After I retired from 21 years working for the city and county of Denver, mostly in the budget and management office, I have been able to start repaying some of my love for native plants by removing invasive weeds from our state parks. It's amazing how the native plants come back from the seed bank when given a chance. I am a member of the Colorado Native Plant Society Conservation Committee, and I have the honor of representing them as part of the Wildlife and Biological Resources Coalition. Today, I'll be talking about the rulemaking mostly in relation to plants, but our coalition is about plants, pollinators, and birds, so I'll try to give them some airtime too. Next slide.
Brad, we're not seeing your slides. I think you need to share your screen.
Huh, okay, sorry.
It's okay.
Let me get back there. I was wondering why I wasn't seeing everyone.
Ms. Larson, turn their time off for a second before we get this adjusted.
All right. So that was my first slide while I was doing that introduction, and these are the members of the coalition. So we
Great.
haven't
Thank
lost anything.
Great.
Thank you very much. I appreciate that. As we know, Senate Bill 181 fundamentally shifted the relationship between state government and the oil and gas industry. Other parties are doing the very important work of advocating in the rulemaking for the protection of public health, safety, and welfare, as well as charismatic megafauna. But where do plants fit into the SB 181 regulatory puzzle? They seem to fit in every category in the ecological values group, but yet not exactly in any one. Plants are certainly part of the environment, but that's pretty vague. They form the food chain, which is the basis for the existence of big game wildlife, but they're not normally considered wildlife. Through their mycelial networks with fungi, plants are the glue which connect water, air, and soils, but they are not equivalent to any of those. They are most obviously one of the main components of biological resources, but it's easy for them to slip between the regulatory cracks, especially when biological resources as a term goes undefined. Plants, their symbiotic fungi and insects are the least clamorous, but the most foundational components of the environment. The plants, including rare plants, which create the habitat for the insects which pollinate and feed on those plants, the nesting and migratory birds which feed on those insects, and the riparian and prairie habitats which are responsible for so much of Colorado's biodiversity. Non-game birds or avifauna, such as songbirds, shorebirds, raptors, hummingbirds, and more, have a similar issue. They are not exactly wildlife, but not exactly any of those other categories either. That's why in the rules, we need a definition of biological resources so that with your help, we can fit WBRC's pieces of the biological puzzle into the overall context of wildlife and the environment in an appropriate way. Oh, there goes my puzzle now. Fortunately, in fulfilling your mandate to protect biological resources from the adverse impacts of oil and gas, you have two very knowledgeable state agencies ready to assist: Colorado Parks and Wildlife and the Colorado Natural Heritage Program at CSU. Colorado Parks and Wildlife, of course, are the big game and fish experts, whose conservation biologists have been hands-on conserving those species since 1897. And CPW led the 2015 statewide planning effort called the State Wildlife Action Plan, or SWAP, the cover of which you see on the screen. This plan identified the 276 species in Colorado, which they called the species and plants of greatest conservation need. These species range from mammals to birds to amphibians, insects, and plants. They are the rarest and the most at risk, the most vulnerable species which support our state's biodiversity. Of course, not all 276 species occur in oil and gas basins, but where they do, these species must be protected through SB 181. These species of greatest conservation need, identified by our state government, should form the basis of what the draft regulations term high priority habitat. This high priority habitat, including not just wildlife, but biological resources like plants and non-game birds, must be inclusively and rigorously protected by your rules. The SWAP is the logical place to start in protecting these most vulnerable species. The SWAP also validated the Colorado Natural Heritage Program's mapping of important plant areas, IPAs, the areas with the highest quality location of plants of greatest conservation need. As you can see, excuse me, here is our map of the Colorado important plant areas from the SWAP. As you can see, relatively few of them are located in oil and gas basins, mostly in the western slope. But where they are, they must be protected. The important plant areas are paralleled in the world of birds by important bird areas, which will be discussed more during the 1200 series rulemaking next month. In addition to CPW, the other agency which can help this commission is the Colorado Natural Heritage Program, or CNHP, at CSU. This group of scientists, botanists, and biologists are the go-to resource for biological expertise in Colorado. They map the species of greatest conservation need from the SWAP and more. They also provide this information already to state agencies like the State Land Board and to oil and gas operators like extraction, so they can identify and avoid the most sensitive biological habitats, minimizing the adverse effects. We urge the Commission to require operators, as a part of the application process, to query the CNHP databases to identify potentially sensitive species on and near the areas proposed for oil and gas development, and to then conduct on-the-ground research to see what species are actually found there now. You may also want to establish a formal consultation role with CNHP. Their expertise is different from CPW's and more relevant to non-game resources. Once the operator, the commission, CPW, and the public have this biological information submitted as part of the application, we can then all jointly determine how best to protect those species through avoidance of these high priority habitats, through using alternative location analysis to relocate roads, pipelines, and well pads to less sensitive habitats, through cumulative impact analysis, and through applying best management practices. Our most at-risk and biologically important habitats and ecosystems identified by CPW and CNHP must also inform landscape level planning. Landscape scale planning and comprehensive area plans can allow us to avoid the unnecessary duplication and impact of multiple ground disturbing facilities from uncoordinated operators acting independent of each other. The State Wildlife Action Plan says the habitat that supports many rare plants throughout the state is underlain by rich deposits of oil and natural gas. Over 25% of plants of greatest conservation need are found in such habitats. Oil and gas development activities and associated infrastructure can cause population fragmentation, habitat destruction and degradation, introduction of non-native plants, and alteration of surface hydrology. Oil and gas development often creates a high density of roads. These roads can provide easy access to new areas for off-road vehicle use. Landscape planning can help minimize these adverse effects. I apologize for the small type on this in the next slide. State plans have identified from 17 to 25 species of rare Colorado plants which are under threat from energy development. This study, the state of Colorado's biodiversity, cited 17 species at high and very high risk from energy development, denoted by the orange and red bars on the upper scale. Motorized recreation is the next highest threat to plants. This map, also from the same report, shows the location of these 17 at-risk plant species, indicated again by the red and orange dots. Most are in the barrens and shrublands of western Colorado, Mesa Garfield and Rio Blanco counties in particular. The SWAP also identified 9 habitats where energy development is a threat to the greatest number of species of greatest conservation need of all taxa. Those habitats are pigeon juniper, shrublands, sagebrush, saltbush, sand sage, mixed and tallgrass prairie, shortgrass prairie, riparian and wetland habitats, and riparian woodlands and shrublands. The upland habitats are where the greatest number of species are threatened by energy development are on the southeastern plains, where they are important bird habitat. I'm thinking of the Chico Basin area, and in the barrens and shrublands of the western slope for rare plants, both areas which may not get the attention they deserve. Unfortunately, the threats to Colorado's rare plants from oil and gas are not just theoretical. In 2012, it was reported to the
Brad, you gotta sum up, you're done. We're going over
the Rare
time.
Plant Symposium that an oil well had extirpated a population of the rare Beck milkfish. This is a Colorado endemic plant. This destruction of a rare Colorado plant population by oil and gas development is avoidable, and we hope you will enact the necessary regulations to avoid future destruction of such a key piece of our biological inheritance. I'm told that my time is up, so I'll just leave you with this slide of the threatened and endangered plants of Colorado and our key points, which Mike has already covered. So thank you very much for your attention.
Thank you, Mr. Clayfin. We appreciate this information. If you wanted to get your slides to Mike, he can get them to Commission's Hearings Officer Larson, and then we'll have this since you were not able to get to the final pieces there. If you could stop sharing your screen, it'll make it a little bit easier for us to ask questions.
Yes. I'm sorry. It's at the top of the screen now.
Ms. Larson, any helpful hints here?
We can take care of this. Give us one moment.
Okay, thanks. Commissioners, while we're waiting, if you could formulate any questions. Okay, there we are. All right, thank you again for the presentation. Do commissioners have questions for either of our panelists at this time? Commissioner McGowan.
Can you hear me?
We can.
Anna came in and helped me out, so hopefully it sounds good. All right, so I am curious if we see the use of the CNHP data set and the swamp areas as part of the wildlife protection plan in a two-way form. Is that what we're thinking about in your testimony? I'm trying to figure out how that's going to fit in. And so to your point too, defining a biological resource, I guess I'm not sure what we have entailed in a wildlife protection plan yet, and I know that we're going to take care of that later in the series. So I'm just trying to fit all the pieces together.
Commissioner, let me try and field that initially. The CNHP, I think it would behoove us to mention it in the 300 series because what we're proposing is they run the query through the CSU, Colorado Natural Heritage Program data set, and some operators are already doing that. I think Extraction was the one that mentioned it. The state land board's been doing it for a few years, so it's mild, it's tried, tested, and true, and it works. In terms of biological resources, we proposed a definition. I think that's going to need to come up on the 1200 series because there hasn't been a staff proposed definition in the rules, in the draft rules to date, and all the parties need to respond and comment on what we proposed. We proposed something that we see very similar. We started, it's grounded in the definition for wildlife resources. And that's where we wanted to start and get some key concepts in there. So I think the third responsive thing I would say is somewhere in the 300, when it's talking about all the plans, we are proposing and recommending that the wildlife protection plan be a wildlife and biological resources protection plan, so that it includes the resources that Brad talked about. And I hope I hit on everything you asked? If not, go ahead and follow up.
I would only add, as I stated in my testimony, that if the operator or COGCC for that matter stood in for them and did the query against the database, then if it was part of the permit application, the public and everyone would have access to that data from the outset, so that we don't have there being a potential completeness review and then more public information comes in. Let's get all of that, the important information from a biological and wildlife standpoint out there at the start of the process, so we're all working on a level playing field.
Real quickly, we do anticipate calling a witness from the Natural Heritage Program during the 1200 series rulemaking, who knows all the ins and outs and will really be able to respond to and present informative information on that aspect.
Great, thank you, Mr. Tropoulos. Commissioner Nanjala.
Thank you, Mr. Chair, and thank you both for your testimony today. I didn't believe I saw in your pre-hearing statements, but I could be wrong, that you provided a proposed definition for biological resources. Did you provide that?
If it wasn't in the 200 to 600 series, we did include it in the recent 1200 series filing. So I'd refer you to that.
Okay, thank you very much.
Thank you. Are there other commissioners with questions? Mr. Tropoulos, I know you had two other witnesses that you presented pre-filed testimony. I'll give you a softball. Did you want to present either or anything from them at this time in the 300, or are we waiting for perhaps 1200?
Yeah, we're waiting. We're anticipating Dana Bove on the 500 and Joanne Hackos on the 400.
Okay.
Thanks.
Great. Seeing no other questions from commissioners, we really want to thank you and your witness for this testimony this morning. Very helpful to the process and raising the issue around the biological resources component as on top of wildlife. So we appreciate that. With that, we will excuse you. And again, thank you for your time.
Thanks,
thank you very much.
At this time, commissioners, it looks like the next place on our docket is party closing statements. And I know that Ms. Larson recently reached out to parties to sort of identify folks in terms of whether they're going to do closing statements. Ms. Larson, do you have that information available yet? Are you still learning from folks?
I have responses in. I have not heard from all parties that have presented, but I have heard from a majority of the parties.
I would suggest, and this is totally up to commissioners, but it's 11:35. What we could do is take our, I don't know, kind of like an early lunch break and say take off for 45 minutes. That will give all parties a chance to get back to Ms. Larson, and then we can tee up party closing statements followed by our staff closing statement or staff response, and then move into deliberation. That's just one commissioner's idea. What do other folks think? Okay, thumbs up, thumbs up, thumbs up. All right. Okay, so it's 11:35. Perhaps we shall reconvene at, say, 12:20. And then Ms. Larson will look to give you a chance to gather everybody together. And so for all parties, we'll convene at 12:20 for closing statements, followed by staff closing, and then we'll move into deliberation. Thanks, everybody.